Okay, good afternoon to all of our participants. Thank you for joining us today. This webinar is hosted by Castle Group and the law offices of Frank Weinberg and Black. Today's course is a board certification. It's appropriately titled The ABCs of Becoming a Board Member, so we expect you to learn everything you need to know in this one shot. No, but it is a lot of information. We are very excited for you to be here, and we hope that all of the content is very relevant to your potential positions. If you have any questions during the course, please feel free to use the Q&A feature. We will be muting the chat feature. So just so you're aware, it'll be the Q&A only, and we will do our best to answer you along the way. Without further delay, let's jump right in. Okay, Michael, if you can just go to the next slide. We have a few housekeeping items before we start. So this is the adjust view options. So if you'd like to see the panel on a side-by-side mode, just click the view options tab and the side-by-side option. And then if you'd like to submit a question, there's a Q&A on your tool panel. There's a Q&A button. Just click it and submit your questions. It should look like this. This is just a view of what the side-by-side looks like. And lastly, the introductions. We have Michael Kassauer, partner at Frank Weinberg and Black. We have Jerry Esposito with Castle Group and myself. Michael is an attorney, all things association law related. He's an expert in his field. Jerry and myself are business development managers with Castle Group, and we are a management company, as you know. We're happy to produce this for you, and let's dig right in. Michael.
Thank you so much, Lindsay.
You're welcome.
So welcome everybody to your condominium and or homeowners association board education program. Per the very, very nice introduction from Lindsay, my name is Michael Kassauer. I'm with the law firm of Frank Weinberg and Black. I'll tell you now, if it's okay, before we dig in, a little bit about myself and my firm. First and foremost, I am with the law firm of Frank Weinberg and Black. We are a mainstay in the Tri-County area. The office was founded in 1987 by Steve Weinberg, who is still an active managing partner of the firm, hardest working man in show business, not anything but a figurehead. He is my mentor, and now I'm proud to say my law partner as well, having been with the firm for many, many years. We have 3 offices in the state of Florida. We have one that is located in Plantation, Florida, another in Boca Raton, and then another in Volusia County, Daytona Beach. We are a mid-sized firm. I consider us a family firm. We have 26 lawyers spread out across our several offices. And I say we're a family firm both because it's the culture of the firm, and also candidly that third office in Volusia County. That was Steve Weinberg's assistant for a number of years. The firm put her through law school. She ended up opening a new office when her husband got a job in Daytona. So we're a very close-knit group. We work very hard together. And the nice thing about the firm and its size is that unlike some community association practitioners, we are a full service firm. We have people that handle all aspects of community association representation. We have people that handle employment matters, construction contracts, construction litigation, collections, all of these things, which some people try to put under a large umbrella of condominium law. Really, they're all different areas of expertise. I myself, as you're going to see on the next slide, I am a board certified condominium and plan development lawyer, which means the Florida bar, their words, not mine, has designated me an expert based upon aptitude testing, basically like a second bar exam, peer reviews, and demonstrations of certain proficiencies and experience in different subsets of condo work. But here's the deal. If you have a construction contract issue for your condo or HOA, it doesn't matter that you're a condo or HOA for most purposes. What matters is that you have a good construction contract. And so instead of getting a condo attorney who's dabbling in construction contracts, what you end up getting by working with our firm is you get a compliance expert like myself who has experience basically in all aspects of community association representation. But you also get, for instance, a Maria Spiliopoulos, one of our partners in the Boca office, who was in-house counsel for a major developer in Southeast Florida before she joined the firm as a partner. So, you know, when you get a construction contract by a construction attorney at FWB, you really get somebody who knows what they're doing. And we have different attorneys that do all these different types of work because we are a full service firm, not for just condos and HOAs, but also various types of businesses and real estate projects and interest holders. To tell you just a little bit more about myself before we dive into the project, I am a partner with the firm. I'm a double Gator, University of Florida, go Gators. I know Jerry agrees with that. There's the chomp. I'm a lifelong South Floridian, born and raised in Broward County. Only time I really left was to go to Gainesville for 7 years for undergrad and law school. Still live in Broward County to this day. I moved all the way from Coral Springs to Parkland. Proud to have two beautiful daughters that my wife and I are raising in Parkland, 4 and 6 years old, 4.5 and 6.5, they would want me to say. And if you ever want to reach out for anything that concerns your community association, I love what I do. I love talking to people. Happy to have a free consult anytime. My email address is on the screen as well as the phone number for our office. Please reach out anytime with questions or concerns.
If I could jump in just for 3 seconds, Mike, just, one of the benefits of being in my position is I get to work with a lot of the vendors in South Florida. And truly, I'm not just saying this because he's on the screen and he's got a nice tie on. Truly, Mike is one of the premier attorneys in association law, and just an incredibly smart and nice person. So if you're looking for a change, or like he said, just to reach out with any questions, he is a wonderful resource to have. And I can't recommend him any higher than possible. So go ahead, Mike, with no pressure now. Now you have to really do a
no, you're in conflict with my best man speech at my wedding that my buddy gave me, where he said that if nothing else, set a really, really low bar out of the gates. That way you can only exceed it. Now I got to find a way to clear the high bar you set. But thank you so much. That's super nice of you, Jerry. It's really appreciated. All right, so this first slide we have here, this is our big picture agenda for what this course is going to cover, sort of like an overall outline. We're going to talk about kind of like the lingo that you're going to need to learn if you are running for the board or were recently elected to your board. We need to indoctrinate you into the language of condo land, I call it, and HOA land. You're equally part of that. We're going to go over the election and recall process. Hopefully you just survived the election. Hopefully you have not had your first threat of a recall, but we're going to talk about the process for how people get on the board, how they get off the board. And basically this is important even if you just completed your election, because if you're a new board member, guess what? You're going to be one of the decision makers for when you have to roll out your election process next year. So it's important that you know what's in store. We're going to talk about operations. That's really the thing that most people think about when they think about condos and HOAs. We're going to talk about things like maintenance and repair responsibilities and the other things that basically deal with the actual infrastructure and administration of the association's various functions. Sale and lease approvals will come up a little bit, although that is its own topic for a more broad breakout course. Records maintenance. You would think this might be something that falls within operations, but this is a biggie. Records maintenance, there is a lot of governance in 718 and 720, the Condo and HOA Acts and Florida statutes, that deals with what is required when you are maintaining official records. There's also requirements for records requests when an owner wants to inspect the records for what you have to do. And this is a super important topic, not only because it is the records and the history of the association for past, present, and future administrations to rely upon, but there's actually a lot of penalties that can arise from failing to comply with these requirements, including if it's a willful destruction. There's actually, as recently a couple of years ago, there's now criminal penalties that can arise if you are willfully destroying documents for some sort of ulterior motive. So this can be real stuff. You want to make sure you do it the right way, and there's a lot of strict rules and things that can arise if you don't do it the correct way. We will dig into it. The next 2 bullet points, budgets, reserves, liens, and foreclosures. This is the lifeblood of community association operations, at least financially speaking. We're going to talk about the budgeting process. We're going to talk about reserve requirements. I'll even make a couple little aside comments about the new, some people call it Surfside legislation, Senate Bill 4D, different things. But basically, in the aftermath of Champlain Towers, there's some new legislation that came into effect several months ago. I'll mention it when we get to reserves. Reserves have been a thing for a long time, but the times are a-changing, so to speak. I will make some passing references to that, but if you need more information, please feel free to reach out to discuss that separately. Liens and foreclosures, this is how you get the money if people don't pay voluntarily. There's a collection process that is prescribed by both statutes, and those collection statutes allow you the ability to secure any delinquency with a lien against a parcel and to foreclose upon the property if the person doesn't pay. It's a very heavy, heavy hammer. It's not something that you can do for every single financial obligation of a unit owner, but it is something that you can do for assessments and associated collection costs. Next up is alternative dispute resolution. That's referring to mediation and arbitration. both the condo and HOA statutes have provisions that deal with how you're supposed to handle certain types of defined disputes, being required to go through an alternative dispute resolution process before you're allowed to go and file a complaint in Broward County, Palm Beach County, Dade County, Circuit Court, or any other circuit court in the state of Florida. Sometimes you got to go through a process for most types of disputes that arise in condos, HOAs, that precedes actually going to court. We'll talk about what mediation is, what arbitration is, and what the different types of disputes are that fall within those respective umbrellas. And then lastly, we'll have, if we have time at the end, or even maybe potentially as we go, we'll see how the pace is. I'd love to answer some Q&A if we have that opportunity. What I will warn you is that this is a course that a lot of practitioners take about 3 to 4 hours to get through. I am a highly caffeinated individual. If you can't see me in the corner, I've got several cups of coffee ready to go. So I'll be talking as fast as I can. I apologize if it comes across like I'm just running through things super fast, but at the same time, I want to be respectful for people's time. I assume some of y'all might be on a lunch break or something like that. So I want to try to get this done in under 2 hours is my goal. I think we can do it. I'll talk fast, but the Q&A part sometimes can break up the flow. So if it happens that we go a little longer, we don't have as much time for Q&A, I apologize, but we'll have my contact information circulated and happy to speak with people afterward anytime. All right. So a couple preliminaries. Where did this course come from? Well, basically, this is all what I call the aftermath of the mid-2000s and the havoc that was created for condos and HOAs. I'm going to leave this all up on the screen, but let me just tell it to you as the story that it is. In the mid-2000s, condos and HOAs throughout the state of Florida experienced 2 major catastrophes. One of them was the hurricanes that ravaged the state in the mid-2000s. If you remember, we got like crisscrossed every which direction, uppercuts, left, right. The storms just kept coming and hitting us, and we didn't even know what to do about it. And what that really brought to light is, holy moly, most people on this planet have their most valuable asset tied up in their home, their condo or their single family house. And guess what? It's governed by this whole complex set of bureaucracy and process and rules that is administered, guess what? By volunteer board members, just like you. So kudos to you for getting involved, but we also have to set reasonable expectations. You can't possibly know everything that there is to know about this just because you were nice enough to volunteer your time to serve on a board. So what ended up happening was the Florida legislature said, hold up, because not only did you have the hurricanes at the state, but I mentioned a second catastrophe. You may be, I'm sure everyone here is aware of the financial crisis. And I cut my teeth as a bankruptcy attorney for a major condo firm when I first came out of school. I saw it was a boiler room with just collection files everywhere around me. So there was a financial catastrophe and there was a physical infrastructure catastrophe. And the insurance stuff created construction emergencies and all sorts of other things that needed to be done to rebuild these properties. Again, people's most valuable asset is their home. And you all of a sudden had volunteers in charge of these big projects, albeit hopefully, if they were in a good situation with a management company like Castle to back them up to try to keep the place on the rails. But that's not enough. With complete respect to Castle, who's the best in the business, the other thing you need to make sure you keep in mind is that ultimately the management company doesn't get to make decisions. They report to the association by and through the board of directors. Y'all are the boss. Congratulations, whether you like it or not. And so you need to know what things are supposed to be a little bit. And that's what this course does. It's basically like a 101 course on what it is to operate a condo or HOA. It's not going to cover everything. And I'm going to cover that on this next slide right here. It's not going to cover these topics that you see on the screen right now because we can't cover everything. It's just not possible. I do separate breakout sessions, and Lindsay and Jerry know that I'd love to do more of them with the Castle team. But the idea is that we can't cover it all, but we are going to cover enough to let you hit the ground running, hopefully, if you're a new board member. And you'll understand the general lay of the land enough to hopefully navigate the rest of the process, especially if you have qualified professional support like the team at Castle. So you're going to see, as another thing, you're going to say, Michael, when we get to some of these earlier slides, why are we covering this? This is, we're not here to get to learn how to be a lawyer. But one of the things that comes up is that, hey, guess what? Just because you're in a condo HOA context doesn't mean that there's nothing else that matters. So we're going to talk about some generic legal principles, names of different tribunals that you may have legal proceedings travel under, And we're going to talk about some of the different statutes that apply, because it's not just the Condo HOA Act. There are other laws and legal authorities that apply to association governance. But now we hit our first warning as we continue down our beautiful journey through condo land. And you see this big warning on your screen right now about governing documents and Florida statutes, and we're warning you about them. Why are we saying that? The answer is because these things sometimes are not what they seem. What do I mean by that? Well, first of all, sometimes provisions of Florida statutes are modified by your governing documents. Many provisions of Florida statutes say, unless otherwise provided by the governing documents, then A, B, C, D, E, F, G. So what that's saying is that the A, B, C, D, E, F, G, that's the default. But sometimes the law allows it to be different if it's prescribed so by your governing documents. That's important because if you go online and you try to Google answers, you might find articles, blogs, newsletters by law firms like mine and my competitors out there that give accurate answers to some degree, but they're not tailor-made answers. Because if you see a generic default answer for A, B, C, D, E, F, G, that's not necessarily going to take into account the unless otherwise provided that might be embedded in your documents. So you can never assume that what you see on the internet or in any of these publications is spot on accurate to community association. The other one that's really big is these cases out here, Cohen v. Grand, FIGA v. Devon Neighborhood, and this is just a couple examples. There's Kaufman v. Scheer and a whole host of others that created this really bedrock principle of Florida law when it comes to condominiums and homeowners associations. And that is this. Under Florida's Constitution, you have a constitutional right to contract and for the government not to impair your contractual obligations. So that means that if you have a written contract with somebody, the government, unless it's really specific circumstances, can't come in over the top, amend the Florida statutes to somehow modify or impair your contract. And guess what? Your governing documents, i.e. your declaration of covenants if you're an HOA or declaration of condominium if you're a condo, that's a contract. It's a covenant running with the land, but it's a contract that governs the relationship between you, your association, and all your fellow owners. And the government can't just change the law and impair that contract in a substantive way for sure. And that comes up a lot because if you go and find a blog article or a newsletter that's talking about the 2022 version of Florida statutes, again, they're giving you accurate information today. But unless you have magic language, something magical is a little colorful, in your documents that automatically incorporates new amendments to these laws, you may very well be locked into a version of the law that existed on the date your declaration was recorded. And that magic language, so you know, they call it Kaufman language in our profession because of the original case that dealt with this, Kaufman v. Scheer. That language is, this association is governed by Florida Statute 718, the Condominium Act, quote unquote, as amended from time to time. And if you have that as amended from time to time language, you automatically rope in the amendments to the statute. If you don't, though, you might be locked into the version that existed on that day, and everything you find on the internet is going to be very confusing and potentially not applicable to your community. So what does that mean? Take your common sense, put it in a box. You cannot trust the internet. Hopefully that's not late breaking news to you guys at this point. The internet is not, with the exception of this webinar, gospel. All right, so now we're actually moving on to that first bullet point that we saw on the agenda for today, the terminology. This is the big lingo stuff you need to know to get your party started. DBPR is the Department of Business and Professional Regulation, oversees most professions in the state of Florida. It could be parimutuel gaming, it could be cosmetology, two professions that I'd like to get involved with one day, but I'll stick as a lawyer for now. And even though I'm told that my hair is fantastic, that is a joke. And we also have the Division of Condominiums and the Bureau of Compliance within that. Jerry thinks my hair is nice. I know that's true.
You do have nice hair. I mean, I'm jealous, honestly, but.
Thanks, Jerry. Thanks. Excuse me. Sorry, I get distracted. But we have under the DBPR that governs all these professions. We've got the Division of Condos. That's where you're going to be mostly hanging out. They also have jurisdiction over some homeowners associations as well, especially when it comes to election disputes. And then another arm of that is the Bureau of Compliance. That's the way I basically describe it is that the Division of Condominiums has an arbitration section that's sort of like the judge. like the courthouse, and the Bureau of Compliance is sort of like the cops. They're kind of like somebody that you can report, infractions to, and they can issue speeding tickets, except instead of speeding tickets, it's monetary fines. They usually send you a letter saying, we've been told by one of your owners that you've done this wrong. Please explain yourself. There's another arm of the division called the Ombudsman's Office. A guy named Spencer Henning is the current ombudsman. And what they do is they deal with any sort of election monitor type situations. So if, let's say, for instance, a group of owners decide that they don't trust the administration of the election and they want to petition for the appointment of an election monitor, they're going to Spencer's office in Tallahassee. And upon presentation of the necessary petition, Spencer will appoint an election monitor. Get this, though, at the association's cost. And that ombudsman, by the way, fun fact, has no responsibility if they make wrong decisions. So I'm with complete respect to Spencer, not a huge fan of the ombudsman process because it doesn't even guarantee you a fair election or a proper election. At the end of the day, the ombudsman could make a bad decision and the association's liable for it. The statutes that we're going to be dealing with. So hopefully there are no cooperatives here, but if you were, you'd be governed by 719. The ones that you're definitely going to have participants today dealing with is 718, that's the Condo Act, and 720, that's the HOA Act, Homeowners Association Act. Both of which are dealing with a category of not-for-profit corporations, because that's what condos and HOAs are. You are a not-for-profit corporation. So you also could be governed by Florida Statute 617, which is the not-for-profit statute. And so the way it basically works, to really give you the simplest explanation, 718 and 720 will control if there's a conflict with 617. But if 718 and 720 are silent on something, you could be doubling back to 617 to get the answers to a lot of your questions. So not just the Condo and HOA Act that matters for community associations. The court system is divvied up into two levels at the most basic description. You have the trial courts. That's where the juries hang out. That's where you decide questions of fact. That's where a case is won or lost in its initial level. Then you have the appellate court system where you could have proceedings, run up for an appellate panel of judges or a single judge to make a determination about the propriety of the trial court's ruling based upon a standard of review. You probably knew that, but the reason I also like to mention this again is about the whole trusting the internet thing. When you deal with trusting the internet, one thing that you might sometimes run up against is that you'll find a law firm who, to their credit, got a very nice result for an association in some sort of matter. But guess what? Trial court decisions don't create binding precedent. So sometimes you might see that something happened. You see an article about this great success, and kudos to that firm. I bragged about it too when I've had those wins. But it doesn't mean that you can count on that ruling to repeat itself for your community association. For that, you want appellate rulings that are categorized as binding precedent. Trial court decisions can be persuasive, as can arbitration rulings from the division. But appellate court rulings are the ones that trial courts are required to follow, assuming it is defined as a binding precedent on that court. Something else that I think is a fun fact, I will go into some trivia as we go along the way. You really are, as you're going to see in all these trivia questions that come up with some exceptions, that you're going to see that they speak to this idea that you're at the epicenter of planned communities here in Southeast Florida, assuming you're not traveling in from another part of the state. In Florida, there's 1.5 million plus declared residential units in over 27,000 projects. And this statistic is a few years old at this point. We have 2.8 million parcels in HOAs. We have 84,000 units in co-ops. And then at the Community Association Institute, and this is a national number, says that we have 10 million people living in residential condos. So bottom line is you'll see that there's a lot of condos everywhere, but Florida's got the biggest concentration, especially Southeast Florida. You're going to see a statistic about Broward, Dade, and Palm Beach counties that, for someone like me, it blows my mind every time I see it. It's just astonishing on a national level how much of a concentration of planned community living we have here on a global scale, really, in Southeast Florida in particular. And now we continue on with my election year rambling. I do apologize if I'm going fast. Hopefully it's going to allow you to get on with your life later today. We're going to talk about eligibility for the election. In the HOA context, and you're going to see sometimes these slides are driven towards HOAs as opposed to condos, you can't be delinquent for 90 days. Otherwise, that blows out your eligibility to serve on the board. You also cannot be convicted of a felony or a crime that is the equivalent of a felony in the state of Florida, even if it was not a felony in the other jurisdiction in which the crime took place. If you are charged with felony theft or embezzlement, then your charge is enough to disqualify you. And if you received any good or service improperly, that is grounds as well for you to be rendered ineligible for your HOA board. Continuing through the protocol of HOA elections, you got your nominees now, and potentially at least you determine your eligibility standards. Now you have to look to your governing documents. Condos are very standardized, as we're going to get to. It's basically prescribed by statute, and that's it. HOAs are heavily governing document driven. So you have to make sure that you're always tracking the language in your governing documents regarding how you conduct the elections. HOAs vary from HOA to HOA. Just because you served on an HOA board previously in a different community does not mean that your election practice is going to be the same. HOA elections also, unless your documents prohibit it, typically allow for nominations from the floor. So you may be finding out who the candidates are on election night, at least some of them. You do vote for people by secret ballot. You have a mechanism to verify that it's a proper owner of voting, of course, but you do have the ability to vote secretly, so you never know who your neighbor voted for unless they choose to disclose that to you. And you should also understand that when you're going through this process, there are different types of terms that get thrown around. Ballots, proxies, written consents, these are all tools that are used, paper tools, to establish different types of votes. When you deal with an HOA election, you're typically going to be dealing with the first two, ballots and proxies. Proxies are typically used first and foremost to establish presence at a meeting if you don't physically attend. It also can be used to assign the right to vote to somebody else. You can do a proxy for quorum purposes only. You can do a proxy to assign the right to vote. And you could also, by the way, have an ability to appear at a meeting by proxy and then separately be submitting ballots, which is the actual voting material in most cases that you say, I want to vote for Jerry Esposito for president of Del Boca Vista because Jerry is, Jerry and Del Boca Vista, those things are synonymous. And if you don't get that, you will soon. It is part of the presentation. Condo eligibility. Now we're into condo land. We've left HOA land, and you'll see on the screen very, very similar concepts. I'm not going to read the slides to you. All of this, I'm happy to share it with you, and you can read it on your own time if you really want to parse the words, but similar concept. You can't be convicted of a felony, and if you have been, you can eventually become eligible for a condo board again at some point in the future, but you need your civil rights restored for a period of not less than 5 years. The big civil rights I hear talked about in this context are the right to vote and the right to own a gun. Those are the two ones that I see come up quite a bit, at least when we have an issue with it. It's not the most common of issues, thank goodness. Your term expires at the annual meeting, but you can be reelected unless otherwise prohibited by the bylaws. If you have a situation where the number of board members whose term expired is greater than the number of people willing to run, you don't have to go through the whole election process. That's nice. It saves you money. You don't have to deal with the mailing costs, which can get a little pricey. Co-owners of a single unit, you can't both run for the board, but you can if you own multiple units. You also can if there's not enough candidates to run. So you can have a situation where you have co-owners both serve on the board, but you either need to have multiple ownership interests in the property, meaning more than one condo unit, or alternatively, you need to have a situation where not enough people are running for the board. So why not allow a husband and wife to serve at the same time, by example? Second to last bullet point, the Division of Condominiums does have the power to suspend eligibility of a director. But candidly, I've talked to a lot of people in my profession, not just in my firm, but at all the other big firms that do this type of work. Nobody I know is aware of the division having pulled this lever. I bring it up because a lot of times I'll get the question, well, Michael, what can we do to get someone off the board? This guy's a problem. He's given management a hard time. He's given the executive board a hard time. He's just disruptive. He doesn't mean well. Well, the answer to that is theoretically the division could kick him off, but just have not seen it happen. I look forward to an opportunity to deal with the issue one day, but unfortunately has not occurred just yet. The other thing that can render somebody ineligible is that as of the deadline for your notice of intent to be a candidate, 40 days before the election is what is prescribed by statute. You can't be delinquent in a monetary obligation of the association. Otherwise, you'll be rendered ineligible. And by the way, if you become 90 days delinquent on any monetary obligation, then you will be automatically removed from the board, even if you've already been duly elected. And I just mentioned before that 40-day mark, that's the deadline for the notice of intent to be a candidate. Here's the other critical deadlines that you have in the condo election process. The first notice of annual meeting should go out 60 days in advance. The notice of intent to be a candidate, that's where you say, I, Jerry Esposito, want to be the candidate for the board. You submit that 40 days in advance. You get another 5 days if you wanted to submit your resume, or they call it a candidate information sheet, 1 page, 8.5 by 11. Basically, you can put whatever you want on it. And then somewhere between 14 and 34 days, that's when you mail out what I call the second notice package. It includes a notice of the meeting, includes the rules for voting, it includes a ballot material, and it includes the outer envelope and inner envelope, which are those envelopes that you may remember help you keep your vote anonymous and also help you identify and confirm that the person voting is in fact a proper representative of the ownership of the unit that is entitled to vote. We talked about the condominium ombudsman process. That's what I mentioned, that 15% of the owners can petition to make the state of Tallahassee, the Division of Condominiums, come down and appoint somebody to run your election for you. But like I said, you have to pay for it when the owners petition for that. And guess what? You don't even get the safe harbor of knowing that your election is going to be deemed valid if a challenge is raised. Because at the end of the day, if the ombudsman's wrong, so is the association. And the ombudsman won't be a party to your election dispute. So it's a really troubling thing in that sense.
Michael, I just wanted to throw in, there's a couple questions that came in that are relevant to this topic. One is the COA subject to optional or mandatory mediation or arbitration in contract disputes with a vendor? And then the other one has to do with the process for a tie vote for, let's say if it was 5 directors for an HOA, but we can start with the first one about the mandatory mediation regarding a vendor dispute.
So there is no requirement in 718 or 720 when it comes to vendor disputes to go to mediation or arbitration. But you should look to your contract, because if you had an agreement with that vendor to go through that process, you could privately agree to it. The other thing to keep in mind is if you're dealing with a construction defect setting or dispute, that is subject to another statute, Florida Statute 558, which has a mandatory pre-suit dispute resolution process. And that's something that could come into play as well with a vendor dispute concerning the contractual matter. But otherwise, no, 718 and 720 do not have specific requirements.
What if there's a tie, Mike, on if it's a board and it's for the 5th director spot and there's a tie vote? What do they do?
So if you have a tie, and I'm assuming for the purpose of your question, Jerry, there are 5 seats up for election, and then the 5th place spot, because who cares if there's a tie between 1st and 2nd place? Everybody gets a directorship seat. It's not like 1st place gets to be the president. That's not how it works. If you had a tie for that 5th place seat and there are 5 seats up for election, then you need to do a runoff election. And the Florida Administrative Code breaks out an entire process on how you're supposed to implement that runoff. It's basically like starting all over again with the second notice, except you'll only have the people that tied for the 5th place spot would be the ones on the ballot.
Is it possible to do that runoff on that night of the election and just everyone stay a little longer and get it done? Or do you have to renotice it and send it out and replan everything?
The latter. You have to renotice it and go get to ride all over again. Continuing on. Quorum. Remember I said unless otherwise provided, A, B, C, D, E, F, G. Under both the Condo and HOA Act, and you see that condos and co-ops are 50% plus 1, HOAs are 20% plus 1. These statutes both provide the default. Your governing documents may say something different, in which case your governing documents may control. So these are the default quorum requirements. Quorum is what it takes place, to be clear, in order for you to have a valid membership meeting. There's a quorum requirement for board meetings, which is typically a majority of the board. But then in order to have a membership meeting where you might vote on things like, the election for an HOA, you need to have quorum. For condo, you don't need a quorum for the election. But for a material alteration vote in a condo, or an amendment to governing documents in a condo or HOA, with the exception of the rules and regs, that's a membership vote usually. And so for all these things, you need to have a quorum present in order to have a valid membership meeting. So that is basically in order to even convene. That is what's required, regardless of the outcome of the vote. You don't even get to take a vote unless you get a quorum. Fun fact, boards don't have an obligation to get a quorum. And this comes up most often in the reserve setting, where a lot of boards will say, guess what? We don't really want to waive or partially fund reserves. We think fully funding our reserves is what's in the best interest of this community. Sometimes owners will come to my boards and say, well, wait a second, why didn't you include a proxy in the budget mailing package? Well, the answer is number one, it wasn't required, but number two, why are we going to give you proxies to waive or partially fund reserves? Because as you're going to learn at a later slide, the board ultimately can choose to fully fund reserves even if the owners want to partially fund or waive. It is what I call a permissive vote of the members, meaning they're giving the board the option if they choose to waive or partially fund. The board can't waive or partially fund without the ownership agreeing to it. But if the board's already decided we want to fully fund, they don't need to seek a quorum for that reserve vote. They can just choose to kind of not pursue it because at the end of the day, they're happy with that. Sometimes you even see HOAs take a similar approach for the annual election, because if you don't get a quorum for the HOA election, which is pretty common in the HOA context, the old board carries forward. Sometimes that's used obviously for a self-serving purpose, you might guess, where a board says, you know what, we're not going to try to solicit a lot of proxies for the election because we're content with staying in power. And guess what? No duty to push for it. So for what it's worth, you do not have to go pound on doors and say, hey, we're not going to get to have an annual meeting if you don't submit a proxy. You maybe ethically you feel like you should. I respect that, but legally there's no requirement to push that. Term limits. This is a condo thing. And this is something that there was a dispute about whether it was retroactive or prospective, but the Glanz case is the one that ultimately won the day here. And basically in 2026, if you're still on your condo board and you've served on it since 2018, meaning that you've had 8 consecutive years that began to run after the effective date of this statute that came into effect in 2018 or 2019, depending on which way you look at it. They made a tweak in 2019. Then the result is that you can't get reelected after 8 years until unless you have 2/3 of the voting interest voting in your favor, as opposed to a majority or a plurality. You actually need to get at that higher threshold to get reelected after 8 years. But simply put, this is not an issue for you to worry about until at least 2026. And when you get close to 2026, if you think you might have somebody that's got 8 years running, before you put out your election documents, talk to your lawyer. But, as we sit here in 2022, I'd be very proud of myself and very impressed with you if somehow you remember that in a few years. So really, again, 2026 is the first time this is even going to matter for a single association in the state of Florida, because it has been determined that it is prospective only, meaning that you only start counting the 8 years after the statute came into effect, which again, it was 2018 or 2019, depending on how long the terms are on your board of directors, will dictate if it's 2018 or 2019, the clock starts to run. All right. Voting certificates, powers of attorney, POA is powers of attorney, not property owners association here, proxies and as it relates to condo elections. So first of all, if you have an individually owned unit, you don't need to worry about any of this stuff. Joint ownership, you probably don't need to worry about it either. Usually documents say that you're allowed to do it. You're allowed to determine amongst yourselves, especially if it's co-owned by a husband and wife, you just get to make a decision. If you're a trust, then you don't need anything to verify that you're entitled to cast a vote in the election, assuming you're listed as a trustee. Often that's on a deed, the deed of conveyance of the property. For corporately owned units, the division has generally held that we can rely on SunBiz, Florida Secretary of State Corporate Records, and if it's one of those categories on the sub-bullet points, president, vice president, secretary, treasurer, managing member, general partner, that's going to be close enough. That it'll probably be deemed valid. But there's also a concept called a voting certificate, which is where a corporately owned unit can designate somebody as a voting representative. But that person has to have a relationship with the corporation of a certain degree. And there's disputes about what degree that is. But my belief is that it has to at least be employee or greater, not an independent contractor or a realtor or anything like that. It's got to be somebody that's actually part of the corporation that you are appointing. Otherwise, it would be a proxy, and proxies are not allowed in condo elections. They are in HOAs, they are not in condos. You cannot proxy your vote to another owner in your community, by example. That is prohibited in condominiums. Condo crimes. I mentioned this earlier. This came down the pike in the late 2010s again, when there was a Miami-Dade County grand jury report that was issued. I think the process was spearheaded by somebody in the Florida legislature, because it turned out that condos, especially in Dade County and with Florida being known the world over as a sunny place for shady people, there have been a lot of people that have abused their positions in condos and HOA boards. So there are now criminal penalties that come with these things you see on the screen right now. So now don't get too crazed. Like that last bullet point, failure to provide records, that's not a criminal act if you do it in a more benign way. If, for instance, though, somebody was hot on my trail for something that I did that was a breach of my duties to the association, and I went into the management office and I started tearing up pieces of paper and flushing them down the toilet so nobody would find them to cover up something bad that I did, that has a criminal penalty. So it's not all obstruction to records, it's specific types. But if you basically, the way to view this is if you are using your position as a board member for something that is designed to benefit you or people in your family or people you care about, and rather than wearing your hat as a director, looking out for the best interest of the association, you could be stepping on one of these things. Beyond that, don't worry about it. If you're not doing things in a way designed to help you and people you care about, meaning like not your constituents in the association, but helping, your family members or your friends, then you're fine. If you do things though to kind of self-deal like that, you could be tripping on some real criminal penalties. So be so noted, misdemeanors and felonies we're talking. Continuing in trivia time, the first condominium in world history. World history, the answer is 434 BC Babylonia. Fun fact there, and you can share that with all your friends. And then recalls. We have the other Jerry, not just Jerry Esposito at Del Boca Vista, but we have now, as we move on to the recall topic, the most famous recall in condominium history. Hopefully we have some Jerry Seinfeld fans, in addition to Jerry Esposito fans here on this Zoom today. This is Morty Seinfeld in the famous episode where Del Boca Vista, where he was recalled from the board of directors because Jerry gave him a Cadillac. He was happy to do something nice for his dad, big successful comedian. So he buys his dad a Cadillac. And everybody thinks that Morty was on the take, stealing from the HOA or the condo rather. So they all ended up recalling him from the board. And there's Morty Seinfeld doing his best Richard Nixon impersonation as he gets on to Marine One. And although in this case in the Cadillac DeVille, I think it is, and leaving Del Boca Vista in shame. Great Seinfeld episode. And in Condo Land, we will take that pop culture reference. We don't get a lot of them. We got that. And I think there's an Allstate commercial once where they made fun of some HOA directors. All right. Recalls now. So we explained the process a little bit. I don't want to get too in the weeds on the procedures of recalls because it's pretty technical, but you should understand that know this. If you have owners that are seeking to recall you, there's two methods they can use to do it. Number one is they can do a petition for a recall meeting to take place. They submit a certain percentage of voting interest, and once they're verified, you have to call a meeting. People can then go to the meeting and vote. The other option is that you could do a balloting process that deals with the recall and the replacement. It's a higher voting threshold. You need a majority of all the voting interests, but it's a way to basically get rid of people and put in their replacement without even convening a meeting. And then there are different requirements to conduct a meeting to either certify or decertify the recall within a certain period of time after you receive the petition. But bottom line, if you're anywhere in this realm of a serious recall effort, reach out to your association attorney. It's a highly technical process, and you really want to make sure you're dialed into those protocols. It's not something that's worth even trying to fully brief you on right now because it gets too in depth to be worthwhile in this course. But talk to your lawyer. There's lots of procedural requirements for recall. And if you get recalled or if you just reach the end of your term, do not do what this cartoon says. Do not shred everything. I understand that you may want your last act after having been tormented potentially by your owners for a period of time to be to shred everything. Don't do it. That is my advice to you as counsel, even though this cartoon hopefully made somebody chuckle along the way. All right, operations. This is the meat and potatoes of community association operations. This is basically how we function. We're going to talk about your governing documents and the different categories of them. We're going to talk about the board structure and its operations and also how you conduct the meetings of the board and also the membership meetings. Insurance is going to be its own topic. There are specific requirements for insurance, especially in the condominium context, more so than the HOA context, at least when you're talking about requirements of statute. Also a really interesting topic this year because, as I'm sure you probably know if you're on this Zoom, condos and HOAs have been devastated by the insurance crisis just like everybody else. I myself experienced a 40% increase in my premium for my HOA, for not my HOA, for my personal home. And I'll tell you that my HOA had a similar increase, and all my condo and HOA clients, 30%, 40% increases. This is pretty standard stuff. If you're less than 30% this year on your increase, you should be pretty happy, but this has blown out a lot of budgets. It's a serious problem in the condo context, the HOA context, and beyond. RRM, that's another fancy term that we're going to use today. That's repair, replace, maintain. That's basically taking care of the physical plant of your condo or your HOA. Amendments, we're going to talk about amending your governing documents, what the processes are for the different categories. They do vary. For instance, amending your declaration is harder than amending your rules and regulations. Contracts, bidding process, bidding requirements, we're going to get into that as well. Rule violations, fines, suspensions, things like that we will dig into. But first, we get more trivia. Give the people what they want. What is the first condominium in a U.S. Commonwealth? Commonwealth is the clue here. It is not a state. It is a Commonwealth. And one of the most notorious Commonwealths that could ever be in the United States is, of course, Puerto Rico. And in 1956, they developed their first condo down there. Stateside, a lot of people jump to New York City, but they would be wrong. The first condo in the United States was Greystone Manor in Salt Lake City, Utah. And we have a very famous, I don't know, Jerry, Lindsay, maybe you know the answer to this. What do you call someone from Utah? Is it a Utahian? Utahite? There's Greystone Manor. Rhetorical question. Don't worry, guys. You don't need to jump in with that. But who drafted the first condo declaration in Utah? It is a namesake of a famous Utah politician. That is a clue that maybe could allow someone to get close. There's really, I think, only one Utah politician that people tend to guess. Maybe John Huntsman's another one. I feel like people know him. But Keith Romney drafted the first condo declaration. I think Keith Romney was like Mitt's uncle or great uncle, is what somebody once taught me. Keith is no longer with us, but his declaration of condominium is. Thank you, Keith, for bringing declarations of condominium stateside. Handsome man as well. Thank you, Keith Romney. All right, first co-op in Europe to continue down trivia time. We have to go to France in 1720. Good times. The co-op game gets started in Europe, in France. First co-op in the United States, that's when we go to New York City. One after another. New York City is big co-op country. There are more co-ops in New York. They are rare animals down here in Florida. I think there's less than 100 in the state of Florida. Longest operating co-op, 34 Gramercy Park in New York City. Fun fact. All right, governing documents. Here's the four big categories you deal with. The declaration, that's like your constitution, a covenant running with the land. Articles of incorporation form the corporation. The bylaws set forth governance procedures for how you run your meetings. And the rules and regs typically have a lot of overlap with the declaration, although the declaration reigns supreme. And the declaration also spells out typically your rulemaking authority and what the scope of it is. And then the board, more often than not, although some documents are different than this, the board has the power to promulgate rules and regulations upon a mere board vote, whereas the other three categories, more often than not, are going to require a membership vote, which is a much more difficult task. The board is comprised of directors, and those directors then choose from amongst themselves, and sometimes they can choose people that are not even directors, if your documents allow it, to be the officers, the president, the vice president, secretary, and treasurer. The president or the board, depends on your documents, also gets to populate committees. So you can establish these different subcommittees to help advise the board and sometimes even have some level of decision-making authority based upon either presidential appointments or board member votes to appoint the committee members. As a director, now that you've gotten elected, congratulations, you owe a duty of care and a duty of loyalty to the association. Again, not going to read from the screen, but I'd like to talk about the fourth bullet point you see on the left side. It also goes into the fifth bullet point a little bit too, and that's the business judgment. Why do I bring this up? I want to assure you of something, because being on a board is stressful. I'm not just a condo attorney. I serve on a board. I know what it feels like. And you're never going to make everyone happy. And even beyond that, you're never going to be right all the time. If you are, congratulations, you are a much better person than me. But the point that I want to make here is that exercising a duty of care, a duty of loyalty, being a fiduciary to your association does not mean you always have to be right. In fact, Florida law offers a special protection called the business judgment rule that just says that you have to have been acting reasonably when you made your decision. And if you weren't being arbitrary, capricious, or operating in bad faith, then if you're wrong, we're not going to hold that against you individually. Sure, the association may pay a price. Obviously, you want to have your directors making the best possible decisions, but don't let people nag you into saying, oh man, had you gone with this vendor, we would have saved a few bucks. Well, as long as you're not being arbitrary, capricious, or in bad faith, maybe you had a good reason for doing what you did. And maybe hindsight's 20/20. But just because hindsight's 20/20 doesn't mean you have to have stuck the landing before you got to the point of hindsight. If you exercised reasonable judgment at the time you made the decision, then guess what? You're good to go. You should have some, for most purposes, obviously litigators will have their way, but the business judgment and rule in Florida will protect you. Conflicts of interest. Now we're getting close to the contract realm a little bit too, or any type of other decision making by the board. There are two statutes, one in the condo context, one in the HOA context. There's also part of 617, that was the not-for-profit statute, that talk about the protocols for dealing with conflicts of interests. This is another one that when anything comes up that smells like a conflict, you should talk to your attorney, because the analysis is fairly involved. For instance, there are different categories of conflicts of interest. This is in the condominium context. I'm not going to read it all to you, but you'll see that you have certain categories of things that are prohibited, some that you can do even if there is a conflict, where you get special approvals by 2/3 of the independent board members. You have a disclosure requirement to the next membership meeting of the conflict vote. And then you also have an ability to cancel the contract if you're dealing with a contract that constitutes a conflict. Now, what constitutes a conflict? Typically, it's within, and let's see if you can remember this vocabulary word. It's my favorite. It took me a lot of times trying to get it right. If you are within 3 degrees of consanguinity, then you are, in fact, in a conflict setting for the purposes of the statute. So what does that mean? You'll see these little numbers in the top left corner of each of these little boxes. If I was entering into a contract, I'm the person in the top left corner, with a child, a grandchild, or a great-grandchild, that's the column flowing underneath the person, then that's within 3 degrees. It's a conflict. If I was going to my parents, you'll see there's a 1 on top of that box. And if you go down, you'll see all the way to nephews and nieces is still 3 or less. If I have a great nephew or niece, I do not need to disclose it. If it's my first cousin, I don't need to disclose it and deal with the conflict analysis. There's ethical conflicts and legal conflicts. Maybe you want to anyway, but 3 degrees of consanguinity is when you trigger the mandatory legal requirements for conflicts of interest. And this chart is a nifty little tool if you need something to confirm whether you fall within 3 degrees of, say it together, consanguinity.
I have a quick question, Mike. Can you say consanguinity 3 times fast?
Well, now I'm nervous. Consanguinity, nope, I'm a failure. I can't do it.
No, that's hard. That was a hard question. That was unfair.
No, but can you do it, Jerry?
Absolutely not.
Okay. See, Jerry's smarter than me. He knows how to avoid embarrassing himself. All right. Conflicts of interest in the HOA context. It's not quite as heavy of a lift as the condo context. You do have still some requirements, and again, it dovetails with 617. But here are some of the things you need to think about: disclosure, 2/3 independent vote, next membership meeting. We're going to talk about the difference between membership meeting and board meetings, but pay attention to that. When it says next meeting of members, it's talking about a membership meeting, not a board meeting, where you need to disclose it. And the owners have the ability at that meeting to cancel the contract on a majority vote. Super messy when it happens, because good luck telling the person that you contracted with that they're supposedly dealing with a void contract that has been in effect and operated upon and executed upon for a period of time. Meetings, notice requirements. So you'll see in the first and second sub bullet point here, there's board meetings and membership meetings. And generally speaking, there are exceptions to this. Your documents may have higher thresholds, and there are special categories of meetings. But generally, a board meeting requires 48 hours notice posted. Membership meetings typically require 14 days notice, mailed, or if you have e-voting, notified by a valid opt-in electronic voting process. You also need to give 14 days notice of a board meeting where you're going to be dealing with rules affecting parcel use or unit use, as well as a budget meeting. And some governing documents have higher thresholds. For instance, I have many associations that say the budget notice needs to go out 30 days. So again, don't assume that because the statute says something that your documents don't say something different. It is confusing. It keeps me employed. It will hopefully allow me to keep feeding my daughters. I apologize for you that it creates bureaucracy and confusion, but there are rules and you need to make sure you follow them. Otherwise, you will create headaches for yourself on the back end. The notice should have an agenda on it that lists the items that will be taken up at that board meeting. And at all these meetings, you need to allow owners to speak for up to 3 minutes. Some associations call this the Q&A, but to be clear, there's no requirement to answer questions. That's a choice. It's one that you may find you offend owners if you don't allow them to ask questions. But at the end of the day, you only need to let them speak for up to 3 minutes. Recording at these meetings is permitted. You can establish rules and regulations regarding what needs to be done in order to record, but it is not something that you can prohibit. Statutorily, people are allowed to record meetings. You have to keep minutes. Minutes are records of votes taken and decisions made. A lot of associations go further than that, and it's almost like a transcript. For most attorneys, they'll say they discourage that practice, even though transparency is a phenomenal thing. It just creates some unintended consequences, but it should at minimum be a records of vote taken, the decision made, and what the outcome of the vote was. So for instance, motion to hire Frank Weinberg and Black as a legal counsel for your HOA, a very popular motion. That's one that you would end up having reflected in the minutes as motion made by President Esposito to appoint FWB as legal counsel of the association. Lindsay seconds it. All in favor. 3-2, passes by the skin of its teeth with 2 people who can't stand Michael Kassauer, but 3 who want FWB. And then that's what the minutes should reflect, with the exception of not making fun of Michael Kassauer. It should be the motion made and the vote taken and what the breakdown of the vote was. That's what's necessary. Anything else is superfluous and potentially inviting issues.
Real fast, Mike, I'm sorry to jump in on you, but I get questions all the time from boards about board meetings and, from a property management side, who should run the meeting? Or should it be the property manager, or should it be the board president? That's really a stylistic approach. So, we're at Castle, we're happy to do it either way. Have the manager efficiently run the meeting and organize it and keep it more seamless and organized. That's usually the way I prefer it. But sometimes boards like to do it, so that's an option either way, depending on how you want to run your meetings.
Spot on. I agree completely. And continuing forward, when you conduct these meetings, they are open to the owners. They are allowed to attend in addition to asking the questions and observe. There are 2 categories of meetings that can take place behind closed doors where a quorum is present. And to have a meeting, you need to have a quorum. So you can have still private meetings between one director and a vendor without it being a meeting. But if you have a quorum present, it's a meeting for most purposes. And then they're open to the owners, except if it's a legal issue or a personnel matter. To be clear, for it to be a legal meeting, you need to have counsel present, because the meeting has to be designed for the rendering of legal advice. If it's just the directors talking about the legal issue, it can't be closed door. It also generally needs to be tied to a pending or potential threat of dispute, litigation, arbitration, etc. So, as an example, if I had the board say, Michael, we're thinking about painting the building aquamarine instead of the current pink color that we're enjoying, we want to understand if that's a material alteration. Nobody's threatening the association. It's just the board trying to be careful. That's not something for a closed door meeting, because it doesn't involve pending or potential dispute, certainly not one that's known. Now, conversely, if you start talking about doing this and then, Jerry Esposito's upset because Michael's now the president, or Lindsay's now the president, I'll go with, and Jerry is very bitter about the fact that Lindsay's now president, and he starts making threats to the association. Yeah, Jerry bothers me too, Lindsay. But if you had a situation where an owner's threatening litigation over the material alteration project, well, then suddenly that conversation with legal counsel could be something that's right for a closed door meeting. And so at the end of the day, that's one category of closed door meeting: pending or potential litigation and legal counsel is present. Personnel matters don't require legal counsel to be present. Personnel matters are employment type issues. Not hiring a management company, for instance, that's something that you should make your motion to hire Castle Management at an open meeting. It's actually legally required that it take place in an open meeting, because that's not a personnel matter. That's more of a vendor change. But if, for instance, you were talking about an issue with maybe the property manager at a different management company, of course, if you had an issue with your on-site property manager, that might be a personnel matter, because that's specific to the employee. The meetings are supposed to be governed by parliamentary authority. The division has held, though, that strict compliance with parliamentary authority, Robert's Rules of Order, etc., is not necessary if it comes to a challenge, meaning that most actions will be upheld even if you did not have strict compliance with Robert's Rules or Sturgis or one of the other parliamentary authorities out there.
Just for the record, I'd be very happy if Lindsay was the president, so no problem there. But Mike, I do have a couple questions that pop through here. One of them is from Marvin, and it relates to the topic. Does the 3-minute rule apply to both board and membership meetings?
The answer, as far as I believe, is yes. I could make 100% sure for membership meetings, but I've always operated as in yes. To me, the alternative would be horrifying, because I know it's true for a board meeting, and for a membership meeting to not allow somebody to speak would be completely at odds with the very basic function of a membership meeting, which is to allow the members to have their meeting. A membership meeting is not a board meeting. It is a membership meeting. So yes is my answer. You should allow people to speak.
Sorry, another one from Charlie. Who sets the agenda? Can an owner speak on an item that's not on an agenda? And that says owner, not board member.
That's a really, really good question, actually, Charlie. The answer is that the statutes provide that you're allowed to speak to the agenda items. So again, these are legal standards I'm giving you. Politically might be another thing. Ethically, for you, it might be another thing. Obviously, we all know there's owners in communities that want to hijack meetings sometimes and make it about them. But at this, sometimes there's also good-natured people who took time out of their day to attend the meeting because they had something they wanted to ask you about, maybe the landscaping that might not be on the agenda or something like that. So as a political or ethical or business decision, you may want to allow people to speak to non-agenda items, but legally you are not required to do so, Charlie.
Is that why a lot of times there's open forum as an agenda item? So kind of it's all encompassing?
Yeah. I think that's a fit, because obviously that's, sometimes when people use that open forum phrase, they're referring to just the agenda items, but sometimes you're right. It's a generic term. It could be broader than that. And again, sometimes it's good practice. And the other thing I'll say, this is fortune cookie advice while we're talking about this, but take it for what it's worth or for nothing at all. You're going to deal with a lot of people that are critical of you and critical of the association's operations now that you're on a board. It is instinctive sometimes for people, and again, I'm on a board, I've felt this way myself at times, to say, well, wait a second, I volunteered my time. Where do these people get off questioning things, questioning me, questioning our motivations? If they want to get on the board, they should have run for the board. Try to do your best. Obviously you don't want to indulge people that are abusive, but sometimes it's good to let people speak. I find that a lot of boards get themselves into trouble by kind of stonewalling the owners that are questioning them, but sometimes you can bring those people into the fold. Most of the time I find people want to be heard. Yeah, they want you to do what they're going to say, but you really upset them when you ignore them. If you hear them out and then go a different direction, it takes it lets the steam out a lot in many instances. So not one size fits all. Some bad actors you're never going to make happy, but try to do your best to not necessarily stonewall people unless you feel like it's necessary, is my fortune cookie advice to you.
Yeah, and that's why I mentioned earlier, it is always a good idea to have your manager run the meetings whenever possible. Again, it's a stylistic thing, but you want these meetings to be efficient and productive. And if they drag on and on and on too long, people get upset and irritated and things don't get accomplished. And that's just sets off the pattern of trouble ahead. So anytime you could, have a consistent, organized approach, I think that's always, the way to go.
Agreed. All right, back to trivia time again. Everybody's favorite. What is the largest HOA geographically in the United States? The answer is Poinciana Villages, Florida. Largest HOA by number of residents. If you're a political junkie, you're going to know this one, because every single election cycle, you see a parade of golf carts march through. What is it?
Villages.
There it is. Jerry gets the door prize. Congratulations, Jerry. You have the Villages up in the middle of the state in the famous I-4 corridor. This is, again, an older statistic because we've been relying on these for a couple of years. It was 125,000 plus people. That's why all the presidential candidates, the gubernatorial candidates, etc., they love to go there because it's a retirement community in large part. It's a lot of people, and guess what? People that are retired, they tend to vote in a high percentage compared to the rest of the population, and there's a lot of them right there. There were famous golf cart wars. If you were paying attention to the news a couple of years ago, there were the Trump golf carts and the Biden golf carts. And there are videos on the internet of that getting a little bit heated. All right. Largest HOA conservation area, Viera, Florida. I've never had anybody get that one right. So if you knew it, congratulations to you. 7,750 acres are set aside for conservation in Viera. All right, condo insurance. That first bullet point you see right there was one that was always like a throw-in until recently. But now I get clients calling me saying, Michael, our insurance premium for our property policy for our condo went from 350 grand to $800,000. We don't want to carry this crap. Excuse the language. We don't want to carry it because it's too expensive. We'd rather self-insure. So people are saying, well, what is best efforts? And to me, I'm not going to lie. I think best efforts mean you have to probably purchase that $800,000 policy. Why? Because if you don't purchase that policy, I think somebody could argue that's not best efforts because you could always raise the money. You have the power to specially assess. You could get it if you need it. There's premium financing out there. And the alternative is just very scary for me. I mean, I like I said, I came into this profession in the aftermath of those dual crises that hit the state in the mid to late 2000s. I did first party property insurance claims for condominium and homeowners associations. It was basically after I was a bankruptcy attorney, that was the next area of specialty I went into. I sued insurance companies that didn't pay out on property damage claims when Hurricane Wilma, Ivan, Chuck riddled the state with their winds and rains and everything like that. If you don't have this insurance, you could have catastrophic losses that, again, we're dealing with people's typically their most valuable asset. And to me, it would be so heartbreaking if you didn't have coverage for the building as originally constructed. You'd leave people in a situation where they could be financially devastated. Now, at the same time, I'm not oblivious to the fact that you may say back to me, Michael, but this coverage is somewhat worthless. I'm paying 800 grand and I got a deductible that's 3% of the value of my buildings, because that's typically what you see in these policies is you'll have two deductibles. You'll have one deductible for an ordinary property loss. You know, a hot water heater bursts and water goes cascading down the stack of units and causes damage to the common elements. Typically, that's a smaller deductible, $10,000 maybe. But when you're dealing with windstorm claims, hurricanes, things like that, named storms, tropical storms, etc., there's typically a special windstorm deductible that's based upon the value of the buildings. So when you're dealing with like a $100 million condominium building, because these buildings are expensive when you total up the value of all the units sometimes, and you have a 3% deductible, well, that means that you need to have $3 million in damages before you see a penny. And so if you have to replace your roof, you may not even touch that. I had an association that had $1.4 million in damage. ServPro had to come out to do remediation work in the aftermath of a storm that hit the state. It was a tropical storm that hit the Palm Beach coast, I think in like the mid 2010s. And they suffered, they had moisture intrusion through the windows because it was wind-driven rain, and windows are not waterproof if you didn't know that. Even impact glass is not waterproof. And they got a lot of moisture damage, and they had over $1 million in damage. And guess how much their insurance gave them? Nothing, not a penny, because the deductibles are so high. So I'm mindful of this, but in my opinion, most people, when they buy into a condominium or homeowners association, they're not looking to take on risk through the association. If I want to make a decision to take out a mortgage and go down to the Hard Rock and put all the money on black, that's on me. But I'm typically not looking for a board of directors to be gambling with my nest egg. And I think most people think that way. But just so you understand further, condo insurance purchased by the association covers the building as originally constructed, but excluding everything you see on that final small bullet point. It doesn't, the association's policy does not cover wall, floor, ceiling coverings, wallpaper, tile, marble flooring, you know, and
Is there a technical difficulty here?
Yeah, it looks like Michael's Wi-Fi might have frozen up on him temporarily.
Okay.
Um,
Sorry about that, everybody. He'll be right back.
yeah, I'll send him a text and see what's going on there. But in the meantime, you know, I know we've got about 45 minutes left. Oh, he just left, so I'm sure he'll log back on. He must have had a little IT problem, but so yeah, Henrik, I see your question. Did we lose Michael? I think we lost him temporarily, but I'm texting him right now, and I'm sure he'll be logging on right back here momentarily. So if you don't mind being patient for minute or two, we'll definitely keep you updated. I'm sure he can talk fast. Oh, here he
There
comes.
he
He's
is,
coming back
okay.
on now. Mike, I think you're back, but you're on mute. You're back, Mike, but you're on mute.
I apologize. I don't know what happened there.
No worries. We just
All
joked about your tie while you were gone, but no big deal.
Yeah, I won't forget that. All right, I apologize, everyone. Technical difficulties, but I was saying that you have it's nice to have those policies, the HO6s, because if you have a water event, it allows the insurance companies to go after each other. A lot like when you get into a car accident. I mean, how often have you ever had a conversation with the person you got into a fender bender with? You don't. You had damage to your car, they had damage to theirs. You submit it to your insurance, they submit it to theirs. The insurance companies duke it out, and you don't hear anything else about it. That's what you somewhat get with the HO6 policies when everyone in your association has them, because the alternative is that the association gets sucked into it. It creates discord between owners. So it's really nice when everyone's got coverage for everything and let the insurance companies duke it out from there. All right. The association may make repairs pursuant to a casualty loss. We covered that. And unit owners are responsible for all those other things that you see that are in the exclusion category. So what that basically is trying to say is that if you had a hurricane come and flatten a condominium building, you'd walk back into that building after the association's insurance does its thing, and you would walk into a condominium unit with concrete floors. You'd walk into a unit with maybe bare drywall, maybe with a primer coat of paint. You would have no kitchen cabinets, you would have no floor, wall, or ceiling coverings, and that would be the unit owner's responsibility from there. We talked about this already. I'll fly right through it. The one I'll talk about a little bit, though, is incidental damage at the bottom. Interesting fact, as a default rule in Florida condo land, let's say I had a situation where there's a water leak in a pipe that is embedded in the slab between two units in the floor. And in order to get into it, I need to go into the upper unit and jackhammer out the fancy Italian marble floor that cost that owner $100,000 to put in. And guess what? If you take out a little section of it, there's no matching Italian marble available. It came directly from some beautiful mountain over in the Italian countryside, and you can't get it anymore. A lot of times the owner said, well, wait a second, that's your fault that pipe embedded in the slab wasn't working or needed a repair, and you had to jackhammer out my floor, so go buy me some new flooring. As a default rule in the state of Florida, incidental damage is on the owner, meaning that if it's incident to the association performing its maintenance responsibilities and damage is caused to the owner's interior contents, that's on the owner. Now, some associations do have language in their governing documents, typically the declaration, that says that if any incidental damage is caused to the unit as part of the association maintaining the common elements, in that case, if there's specific language in the documents that so provides, you could have the association be responsible. But if you don't have that special language, it's on the owner. It creates some heartbreaking situations, but it's reality. And the board has a duty to abide by that, because the alternative is you're taking on a financial liability that benefits one owner, even though the documents don't require you to do it. So incidental damage is a tricky thing. It's a hard conversation to have, but it is the rule and it is the law of the land unless you have special language in your declaration. RRM, that was one of our vocab words at the beginning, repair, replace, maintain. There's two scenarios to know about here, and you should understand the difference because they are just that, they are different. When you have a casualty loss or a property loss, meaning an insurance event, you're going to be going under 718-111, and you're going to have broader responsibilities for the association to do their thing to fix some stuff than if you did in a maintenance and repair situation. For instance, windows are something that is typically insured, that is required to be insured by the association. It's part of the building as originally constructed. But a lot of governing documents say that the RRM, repair, replace, maintain, in the declaration might say that the owner is responsible. So if, let's say, for instance, the building makes a decision to go to impact glass, or you individually make the decision to go to impact glass, replace your sliders, replace your windows, go impact because it's safer, it's quieter, energy conservation, whatever your motivation might be. If it's not because of an insurance event and your documents say that's your RRM as a unit owner, it's on you. But if a hurricane came through and shattered half the windows in the building, the association's insurance should be stepping up to take care of the RRM in that case. So the insurance responsibilities and the regular maintenance responsibilities in a non-insurance scenario are not the same. Please be so noted and be paying attention to it when that day comes. Right of access to the units. When you need to access a unit and an owner's giving you a hard time, know that at the end of the day, you have an irrevocable right of access to the unit to perform maintenance to the common elements or to prevent other damage to the condominium property. What does that mean? Well, let's say, for instance, you're in an association where the sliders are the association's responsibility. And let's say, for instance, the track is making a squeaky noise that's irritating other people in the building, and you need to get your maintenance guy in there. And the owner's saying, the squeak doesn't bother me, I don't want you coming in. Well, guess what? They can't stop you. You have an irrevocable right of access. Now, it's a right that you should exercise reasonably, which means you should give reasonable notice. For something like that, where there's a squeaky track on a slider, I think you should give at least a few days and maybe more. And if they need to reschedule for a week or two later, probably should reschedule and work with them to avoid a conflict. Conversely, if there's water flowing under the door because the hot water heater burst inside the unit, reasonable notice might be right now. The thing I just say to that is a lot of the condos have keys on file in the management office. I caution management personnel and board members all the time to be careful. If you're using that key over someone's objection, not a joke. We are a very gun-friendly state, not being critical of it, just saying it is a reality. And you don't even need a gun to be dangerous. So if you barge into someone's home and they do not want you in there, you could be inviting a violent situation. So be very, very careful about exercising that right. You do have the legal right, but be careful about how you use it because nobody should get hurt. But again, also tailor it to the circumstances. You don't need to just barge in if it's something that can wait. Obviously, water flowing under the door cannot wait. I'm going to skip that other part. 719 is the Cooperative Act. I assume there's no cooperatives on the Zoom. Amending governing documents. Remember I said that this is another example of the unless otherwise provided, the A, B, C, D, E, F, G. The default standard is in a condo that you need 2/3 of the members to approve an amendment to the Declaration of Condominium. Again, that's the Constitution. That's the heavy responsibilities that really dictate how your place functions. Material changes are things that change like the size and configuration of a unit, or change the percentage share of common expenses. Literally have never seen it once in my entire career, but if you did see it, it would require 100% approval and approval of all the mortgagees, the lenders, because you're talking about changing the size of someone's piece of real estate or changing their percentage share of the common expenses, something that you shouldn't be able to do unless everybody's in agreement. Then there's material alterations. That's anything, even though this is a whole separate course, that changes the color, use, form, appearance, size, function of any sort of portion of the condominium property. If you're going to make a material change, that could be something as simple as changing the building from white to beige, or beige to white, I suppose is the trend these days. Then that requires a material alteration vote of the owners. But the first and third bullet points here, the 2/3 and the 75%, those are both unless otherwise provided in your governing documents. So take a look. I've had associations say material alteration just needs to be approved by a majority of a quorum. And sometimes a quorum is only 33 1/3%. So you could have 17% of the community approving a material alteration. You could have 17% of the community approving an amendment if the documents prescribe that lower threshold. Otherwise, these are the defaults. If you have amendments to your documents, you know that the way that they are depicted is through additions being an underline and deletions being through strike through, unless you're substantially rewording the whole document, in which case you can put a banner at the top that says that you are substantially rewording things. All of these changes to the declaration and bylaws and articles, and often the rules and regs, should be recorded in the official records of the county in which the condominium is located. And copies of the amendments should be provided to the members, both before the vote and then if there's any sort of modification that occurs afterwards as well. Otherwise, typically notice that the amendment has been recorded as presented can be sufficient in certain circumstances. The last bullet point here is what I call the Airbnb statute. There was a famous case called Woodside that went to the Florida Supreme Court a little over a decade ago. And basically the story of that case is that there was a lot of investors in this condominium called Woodside. And what happened was the association didn't like having these investors in there. So they passed an amendment that either limited or prohibited rentals in the building. And a group of investors mounted a big legal challenge that they took all the way to the Florida Supreme Court. And they said, hold on, this is our property. And we bought it with an expectation based on the governing documents that we could rent. You cannot pull out the rug from underneath me here. And the Florida Supreme Court said, sorry, investors, yeah, you bought your condo subject to a declaration that allowed you to rent, but you also bought it subject to a declaration that included an amendment provision that allows the members to amend the documents. So you signed up for the possibility that the rug could be pulled out from under you. And so that case said, guess what? You can amend the documents to change the ability to rent. Fast forward, the Florida legislature says, well, we get a lot of money from investors here in Florida. And we don't really want to lose that, because if we lose the investors, our property values are going to go down. Basic supply demand, right? The demand goes down because there's no investors buying units anymore. Suddenly the prices go down. Well, the Florida legislature did a legislative fix to Woodside. I'll let you decide if it was really a fix, that said that any amendment that affects duration of rentals, meaning the length of terms that are allowed, a 1-month rental, a 3-month rental, a 1-week rental, that's the Airbnb stuff, or frequency of rentals, meaning how many times you can rent per year. If it's passed, that amendment, it's only binding on people that either vote yes, they have to actually vote yes. So a non-vote or a no vote would result in the amendment not being binding against that person. Let me say that again, a non-vote, meaning if I don't vote at all, but the amendment passes, it's not enforceable against me. If I vote no and the amendment passes, it's not enforceable against me. But if I'm in one of those two categories of ownership, and I sell my unit after the amendment is passed to a new person, that new person will be bound by it. So it's only for my term of ownership. If I vote no on an amendment that, let's say, bans Airbnb in the building, it's not binding against me. If I don't show up to vote, it's still not binding against me. And that's 718.110 paragraph 13. Contracts. Any contract over 1 year to perform must be in writing. And if it's more than 5% of your annual budget or in a condo, or more than 10% in an HOA, you need to undergo competitive bidding. To be clear, competitive bidding, a lot of people think it means 3 or 4. There's nothing that says it's any more than 2. So good practice maybe to get 3, 4, 5, 6 bids, whatever you'd like, but 2 is the mandatory requirement when you exceed those thresholds. Services for professionals are exempt from bidding. What is a professional? The statute prescribes that it is architects, engineers, accountants, and then everybody's favorite, lawyers. Renewals of contracts do not need to be bid again if they are cancelable within 30 days. So for instance, if you have a very healthy relationship with Castle Property Management, and you had a provision that said in their contract that it's terminable within 30 days when you come up for a renewal because they're doing such a great job and you want to stick with them, you don't need to go through some ceremonial task of bidding out to other management companies. If it's, as long as that renewal is terminable within 30 days, you avoid the competitive bidding requirement. All contracts, by the way, are subject to approval by the board. Presidents should not be entering into contracts unilaterally even. There are emergency situations where sometimes things are done. I'm not going to speak to when and where that's proper. That's a whole separate conversation. But boards are supposed to be making decisions for the entity, for the association, not individual directors. Rules and regulations. If you're a recently turned over community and you still have developer inventory, or you haven't turned over yet even, developers can be given special status and exemptions from certain rules and regulations. But otherwise, the thing you need to know is the rules can never be arbitrary, capricious, or in bad faith. But that first sub-bullet point is the one that I'd like to talk about for a second. And that deals with the scope of the board's power. For instance, in a condominium, there are common elements. That's the shared stuff for the most part. Limited common elements can be of private use by an owner, but it's the shared stuff, let's say. And then there's units. And that's my private stuff. Sometimes the rulemaking authority is tailored to say the association has the power to promulgate rules and regulations concerning the common elements, in which case you can create rules regarding the common elements, but that didn't rope in the unit. Sometimes the documents will say the board has the power to create rules and regs regarding the use of the unit. And then you have the rulemaking power there. Sometimes it'll use an umbrella term, like the board has the power to make rules and regs concerning the condominium property. At the end of the day, whatever rules and regs you're making need to be derived from a power in the document. So you need to look at the scope of your rulemaking authority in the higher up documents, the declaration, bylaws, and articles. One of those is going to say what the scope of rules are that the board's allowed to promulgate, and that's the scope that the rules can actually be that you adopt. This is just moving on here. One rule that has been undermined by legislative overthrow, I'll call it, is that you cannot pass a rule any longer that bans police vehicles by trying to couch them as commercial vehicles. This was and is a thing a little bit. There are people who to each their own. There are people who feel less safe when they see a police vehicle. It reminds them of the idea of something bad happening. Maybe they think something bad is actively happening, and that's why police are present, whatever their reasoning might be. There were condos that said, you know what, we don't want to allow police vehicles because we don't want to allow commercial vehicles. And what's the difference between my air around the clock truck or whatever vendor it might be in a police vehicle? It's got lettering. It doesn't look like it belongs in a residential setting. Well, that was ultimately deemed unacceptable by the Florida legislature for many reasons, including the fact that many police officers take home their vehicles, their work vehicles, to their condo or their home, and they shouldn't be forced to have to do something special. So Florida legislature has said you cannot couch police vehicles as commercial vehicles. All right, this is the one where I help you take food out of my daughter's mouths. And the reason I say that is because if you learn nothing from today, and hopefully you'll learn a lot that helps you avoid legal fees because you'll know the answers to questions that you would otherwise ask your attorney. I am not going to lie. A lot of the questions I get all year long from my clients are the questions that are answered in this webinar, in this presentation, in this education course. But this is to take it another level. This is another thing that can help you keep things out of my office, which you should try to do because it costs money. Obviously, you want to come to your attorney when you really need it, but the fining and suspension powers under 718 and 720 are incredible. They've given that in a condo, you can never lien for a fine. So it's not a secured thing that can be foreclosed upon. But you have the ability, without going to a lawyer or a court or an arbitrator or the division or mediation or anything, to have a fine or suspension levied up to $100 per violation per day, up to $1,000. And you set them through a two-tiered process. There's a board meeting to vote upon a fine or suspension. And then there's a three-person independent committee, nobody related to a board member, that then gets to vote to either uphold or reject the fine or suspension levied by the board. And don't lose sight of the suspension thing. I once had a case, I always talk about it when I get to this point in the presentation, representing a high-rise condominium in Palm Beach County on the water. Very, very nice community, units in excess of a substantial dollar figure, I'll say. And there was an owner who was an attorney who had hired a law firm, spent tens of thousands of dollars to fight with the association about his ability to have a jet ski float to park his jet ski on in the dock that he had. And there was litigation that went on for years. About 2 years into the litigation, our firm was hired to be general counsel to the association. And the prior firm had focused a lot on the litigation for good reason. But I said at one point to the president and property manager, did you ever try to do a suspension? And they initially they snickered at me and they said, Michael, this he's a lawyer. He spent 40, 50 grand on litigation at this point. He's not going away because of a suspension. It's a waste of time. And I begged him to do me a favor and give it a shot. So they levied a suspension, and the suspension was that they were rescinding the ability to go through the owner's entrance at the guard gate. And the infrastructure of your property is relevant to this analysis, but they suspended it so they had to go through the guest entrance and show their license. So it turned out that my client was right. The president and property manager were right that the man that was fighting the association had no interest in backing down as a result of that suspension. What they failed to take into account was how his wife felt. And the very next day after that suspension went into effect, the wife came home from Publix or something, and the guard made her go in reverse and pull into the visitor's entrance and show her ID. She went home and she reamed her husband, is what I heard, about him needing to get rid of his stupid jet skis. And they got rid of the jet ski float, and the case resolved within weeks. A case that went on for years. So the power to suspend, especially if you have key fobs and infrastructure controls like that, can be very powerful. You just can't suspend the right to use what I call the essential common elements. You can't take away parking spaces or elevators or things like that. But the fun stuff, and yes, the owner's entrance is considered one of the fun things, that can be suspended. So don't skip over this. You'll keep things out of legal counsel's office a lot of the time if you do the fining and suspension process properly. Emergency powers, this used to be a very small portion of the presentation. It's becoming small again. Thank goodness. It became really big during COVID-19 when we had to deal with all sorts of special powers and had to conduct meetings when a state of emergency has been declared. What I will say is that if we ever end up in a state of emergency or you have a professional engineer or architect tell you there is a safety issue on your property, you need to dig into these things. But in the absence of either a declared state of emergency by the governor or a a declared emergency situation by a structural engineer or engineer of some kind, or an architect, somebody with those qualifications of that ilk, you are not going to be dealing with emergency powers. So if you do get into that setting, though, you might have special abilities to conduct meetings, levy special assessments, and if you have advice from an appropriate professional, you can even render certain parts of the buildings not accessible or limited access. This came up a lot during COVID when buildings said, you know what, we're going to only let owners come in and out. We're not going to have guests or visitors because we just don't want the place being used like that. And emergency powers were analyzed heavily for the propriety of those kinds of actions. But bottom line, if you're in a situation where a state of emergency is declared, or if you're in a situation where there's a structural issue or some sort of physical infrastructure issue, then you need to talk to your lawyer and your other professionals that may be at play about whether you need to be using emergency powers to move forward. This statute was actually amended. That's what you're seeing here a little bit in 2021 in the aftermath of COVID to make sure that there were special abilities. For instance, you'll see in the second bullet point for real-time video conferencing. I don't know about you folks. I am maybe a little bit younger than some of the other people that teach these webinars, but I had never used Zoom once before COVID hit. I used it for the first time ever. I think I might have even been with Castle for my very first webinar that I did within like a couple of weeks of COVID starting. And we all went through a crash course in how to use Zoom, and it was, you know what, it was a godsend. And I think to this day, it's been a godsend. It's completely revolutionized how condos and HOAs can operate and how people can gather and share information. It's incredible. But there was nothing in the statute that addressed whether real-time video conferencing was a permissible way to conduct a meeting. So the emergency power statute has been updated. Unfortunately, the regular statute has not been updated. That's something that I think we need our friends in Tallahassee to get on, because at the end of the day, the idea of physical locations, it might be going the way of the dodo bird at this point. I think most people agree that it is a very effective means of conducting a meeting for us to gather here like this. You get to see the materials right in front of you. Instead of looking at my face, I'm shrunk into a much smaller box, so you don't have to actually see my appearance. So that's a win for everybody involved. But in all seriousness, it's a great way to gather people and circulate information. And it's so much simpler than going and sitting, on pool furniture at the patio or something like that. So I'm a big fan of it. And it's something that the emergency powers now do allow, but the regular statute has not really adapted the same way. It does have some ability to do it, but in conjunction with a physical meeting location, arguably. Okay, continuing on records maintenance. Condos have official records. They have rulemaking for official records, records request rules, things like that. You also have websites in a condo. If you have over 150 units, I believe, then you have to have a website that's supposed to be maintaining certain official records on there, and you can satisfy a records request by sending someone to the website. HOAs don't have the same website requirement, but they do have official records requirements. Basically, all of the records of the association are official records. There are categories that you need to have, but there's a catch-all at the end that encompasses most everything. But what is also true is there are exemptions, meaning that if I make a records request to see Jerry Esposito's sale application package when he wanted to buy his condo at Del Boca Vista, then I'm not entitled as another unit owner to request to see all that. I'm not entitled to see his personal banking information or his email address if he didn't consent to it, as well as a whole host of other things. I can't see attorney-client privilege communications. There are personnel record exemptions. All these things are official records, but there's carve-outs that an owner cannot request to see as part of their right to inspect official records, which every owner does have. Separate from records maintenance, there's another concept out there called written inquiries. This is in the condo context, and it allows you to submit a written question to the association that has to be responded to within 30 days. It can be beefed up to 60 days if the matter is referred to association counsel to give an answer. But at the end of the day, you can ask a certified question that, must be answered in writing by the association. I mentioned there's a laundry list of items that are part of the mandatory official records. You're seeing them right now. Please don't try to read it. It is small. This is coming out of the statute, but all these materials I'm happy to make available. And so feel free to reach out to me or Lindsay, and we can certainly share with you. These are the laundry list of things that you need to have in the association's official records in a condo. And then when you get to the very end, it's actually the second to last bullet point here. All other records of the association not specifically included in the foregoing, which are related to the operation of the association. So basically everything. Condos can adopt rules for inspection regarding the manner in which they're submitted, how often you can submit the requests. You can have costs of copying imposed. Typically, it's like up to a quarter a page. You're supposed to maintain copies at the governing docs at all times on file. A renter has the right to inspect the association's bylaws and rules, and that's it, as opposed to an owner that has the right to inspect everything except the exempt documents. Why the Florida legislature decided the bylaws and the rules, but not the declaration or the articles, Lord only knows. I'll tell you, people in my community sort of laugh at it because it's like whoever wrote this law just doesn't know what they're talking about. Because why would you say the bylaws but not the declaration? It's silly. I mentioned before with websites that you need to have a website if you have at least 150 units in your condo as of January 1st, 2019. And you can now direct people to the website to satisfy a records request requirement. You can also, instead of a website as of 2021, have an app. Because a lot of people these days obviously like the apps instead of having a www.com. Here's the website requirements, the things you need to have on there. It's a laundry list again. It's part of the statute. Materials will be circulated. I'm mindful of the fact it's 1:37, so I want to keep rolling here to try to meet my goal of getting you out of here by 2. Here's the HOA records maintenance statute. Again, another laundry list. And again, if you look at the very last bullet point, it's got a catch-all for the HOAs also. So you got all these things that are part of the official records in both condos and HOAs. It's basically everything. HOAs have the same ability to promulgate rules. I recommend if you're going to do this, that you do it through a written resolution. My firm has enhanced our resolution through the years based on what the Division of Condominiums has deemed acceptable to be basically one of the best documents I think there is in the business. It's best though that you reduce this to a resolution and not rely on the default of the statute, because you can be more restrictive than the statute, but you should have a resolution that dictates exactly what those standards are. Like I said before, just like in a condo, you can charge for copies. You can also actually charge an hourly rate for the use of personnel time that is necessary for that process. I believe it's capped at $25 an hour. All right, here's the exemptions that I mentioned before: attorney-client privilege documents, sale and lease approval documents, personnel records, medical information. If I do a request for a reasonable accommodation, this comes up a lot with emotional support animals, where somebody will say, that is nonsense. That woman's emotional support bull mastiff is not helping that woman with her emotions. It's scaring the bejesus out of me, though, every time I get in the elevator. I want that dog gone. I think it's a nonsense emotional support animal, and I want to see the request for an accommodation. Well, guess what? That may not be something the person gets to see, because those requests for an accommodation are typically supported by a medical prescription. So you can't necessarily share it. It can be a contested issue, or at least something that upsets people in your community. There's also personal identifying numbers, social securities, driver's license, credit cards, emails. These things are exempt. Electronic security stuff. You can't do a records request for the property manager's list of passwords to the association's databases. Just because it exists as part of the records doesn't mean you're going to get it. So let's again say that everything is an official record, but there are carve-outs, and that's what you're seeing on the screen right now. Records requests need to be in writing. Email is not in writing unless you decide to make that your practice. They should be delivered to the board or its designee. It's a right to inspect, not a right to copies. You can pay for copies, but you're not entitled to them. Otherwise, you just get to look but not take. You have a right to the inspection within 10 working days. Let me be clear. You see 10 days on the screen, it's 10 working days. You have no obligation to create a record that doesn't exist. So sometimes I'll get a request for a list of some kind. Well, we have the information that could create the list, but we don't have a duty to create it just because you submitted a records request for a list that's not in existence. Written inquiries, these are the certified questions I mentioned before. They need to be delivered by certified mail, not just in writing, but by certified mail. And then you have 30 days to respond. You can buy another 30 days for the attorney to make it 60. You can also use 60 days if you go to the division to try to get them to give you a ruling to help you answer the question. Failure to comply with these requests, either a records request or a written inquiry, can expose the association to an adverse award of attorney's fees against them for failing to comply with the requirements under 718 or 720. So bottom line is save everything. Records maintenance is ominous. It's daunting. It can become a distraction when a records request is submitted, but you don't want to get caught breaking the rules on this front, even if it's just a difficult owner, because I'm not going to lie, 9 out of 10 times, the person submitting records request is just trying to harass people. Unfortunately, that's just the reality of it, but you still want to play by the rules. You still want to save everything, because even when people get super difficult with you, you always, in my opinion, not always, but most of the time, try to wear the white hat, because you don't want to roll around in the mud with them. You'll get dirty too, and you should hold yourself to a higher standard, because otherwise what happens is you reduce yourself to their level, and most of the people in the community probably are not giving that person the time of day, or they recognize them for what they are. Don't go to their level, because then those nice people in your community that are not judging you are going to lump you together with the bad guy. So play ball, do the right way. Even if the motives of these records requests are bad, do the right thing. And yes, keep everything. Trivia time. When did Florida adopt its Condo Act? 1963. What attorney helped write it? Ralph Boyer, the namesake of the University of Miami Institute on Condominium and Cluster Development, where there is a very nice event every single year hosted by the good people at Castle Property Management. And that the Institute is a great thing. Ralph Boyer is the namesake. It's our big annual convention of condo lawyers where we get together and share the latest and greatest. The HOA statute's much newer. Obviously, there were community associations that were not condos that existed before 1995, but they didn't exist under Florida Statute 720. If you take a look at Florida Statute 720, you'll notice that it starts at 720.301. Why? Well, because before the HOA statute existed, the HOA Act was part of the not-for-profit statute. And when it was in the 300s. So it would be 617.301. So basically what happened is 617.301, with the 300 at the time being the HOA stuff, and the 100s and 200s being generic not-for-profit stuff, the 300s were picked up and put into new 720. And that's why 720 starts in the 300s since October 1st, 1995.
And Mike, super fast question here. It's from Marvin. Condo records requests are 10 working days or 30?
10 working days. It is 30 days to respond to a written inquiry. It is 10 days to respond to a records request, Marvin. All right. Budgets. All right, so here's the financial stuff. You have a budget meeting where you adopt your annual budget. You have collections. You have estoppels, which is when you have a change in ownership. You get to basically say, what is the status of this unit? Are there violations, or is there a monetary delinquency owed? Rentals we're going to talk about as well, because when you go into collections, you have special rights to go after a tenant. If the owner is delinquent in assessments, you can actually hijack the rent. And the tenant cannot be evicted by the landlord if they are paying the rent to you because the owner is a deadbeat who's not paying the condo. Multi-condominium issues, we'll talk about that briefly. You'll know it probably if you're a multi-condominium. That's basically where you have one association, but you have different declarations. For instance, our firm does a lot of work with Sunrise Lakes in Sunrise, Florida, if you're not familiar. And Sunrise Lakes has declarations for each building. So you'll have Sunrise Lakes Phase 4 Inc. 3, and then within Sunrise Lakes Phase 4 Inc. 3, there will be building 10, 11, 12, 13, and each building has its own declaration. So they're different condominiums, but it's one association and one board of directors. On the revenue side, I think this graphic's actually a little interesting, because what it goes to me is the law of the denominator, which is that you always should be thinking about your expenses in terms of how it's going to affect people at the end of the day. And what that means is that if you're in a building that has 10 units and you go out and you spend $10,000, that means everyone's kicking in $1,000. But if you have an association that has 100 units or 1,000 units, obviously that same expense is not going to inflict quite as much pain. So the ant colony with their 1.8 million residents, they're going to be in a better situation to absorb some certain expenses, because the law of the denominator means they get to chop it up into smaller per unit or per owner liabilities. Condo meetings, we talked about this before, that one of the categories is the budget meeting. By default, 14 days written notice to every owner. You're supposed to include a copy of the budget in that notice, and as well as a schedule of how that breaks down. Unit owners can vote to reduce or partially fund or waive reserves. At least they can for now. We'll talk about that again briefly. But that's, again, a permissive vote. It's an empowering vote for the board. It is not a vote that the board has to follow. So the owners can say, we want to waive reserves, to keep our assessments down, and the board can say, sorry, I know it'd be nice to pay less, but we think that's a crazy thought. We need to make sure we have enough money that if we have an issue down the road, that the cookie jar is full of the resources that we want to draw upon. So the board does not need to give the owners to even conduct that vote, because again, they could just choose to override it. Substitute budgets. This is one that it also didn't come up until recently in my career. It came up a lot this past year, though, because of the insurance crisis. Typically, a 15% increase in an annual budget was something that was unheard of. Not never, but it was rare. This year, though, it's happening a lot, because if you have, the property insurance for a condo especially is one of the biggest items in the budget, hands down. And so when you have that line item go from $500,000 to $800,000, that has a real effect, and it pushes you to that substitute budget range. And I've had some people that have tried to execute on this. I even had some people successfully deliver the petition for the meeting a couple times. It's a complex process that they have to deliver a budget that most CPAs say needs to be apples to apples. You can't just say we're not going to pay the property manager or something like that, because obviously there's necessities. So you got to be doing a fair comparison. But if 10% of the owners petition for it, then you can have a membership meeting where the owners can override it. I've never had it successfully done. At the end of the day, it's really hard for people on the outside to make these decisions over the board. Because there's most of the time I find that when you get into the financials, you learn that nobody wants to see their assessments go up 18%. That's literally what's happening in my HOA this year. I didn't like getting that news, but at the end of the day, it's reality. Most of the employees of the vendors that are servicing your building, management personnel, security personnel, hourly rates are going up. Costs of goods are going up. This is real. The inflation situation is real. And so you can't expect these things, the budget, to be stagnant. And people are exceeding that 15% increase, which is causing substitute budgets to be a possibility. But again, it's more theoretical. You're more likely to have it threatened than ever actually implemented. I talked about this before. The annual budget, you need to have detailed classifications of expenses. You need to state your expenses on an annual basis. You need to break down your assessments based on the installment periods, monthly, quarterly. You should have your estimated expenses of what you anticipate over the year. You should include your reserve contribution amount, assuming that's what you're going to do, which is the default. Limited common elements must be separately budgeted if only one unit owner maintains them. To explain what a limited common element is, I know I briefly broached upon it before. Common elements are the things that everybody gets to use. And there are also things that are maintained by the association and paid for by the association. Limited common elements are common elements that are maintained by the association, but for the exclusive use of one or a group of owners. Typically, that's a parking space, balcony, things like that. And sometimes it'll say that the cost of the limited common element are passed along directly to the one owner. So basically, if I have a carport that is a limited common element, it can say that I'm responsible for my cost of the carport. That way, if I'm a different owner that doesn't have a carport, I don't have to kick into it. So limited common elements are a special class of common elements that are for the exclusive use of one or a special group of owners, and they need to be separately budgeted if only one owner is responsible for them. HOA budgets are a little less restrictive, but they still have these requirements to break out the fees and charges, give the estimated expenses, and provide for reserve accounts if applicable. Reserves are not the default in HOAs. Let me be clear about that. But if it is a requirement, then you should have it in the budget. Reporting requirements. Most condos of any substance, meaning size, are going to be getting full-blown financial audits every year. It doesn't take much to get to a budget of over 500 grand, especially these days. You can have simplified financial reporting requirements if you have a budget that is in one of those lower thresholds. Cash expenditures, compiled statements, reviewed statements. Obviously, your CPA can delve into what these things are, but for most condos, you're getting a full-blown financial audit every single year if you have a budget over 500K. Trivia time again. What U.S. jurisdiction's another flag word here, does not have a condo law? What U.S. jurisdiction? I'll give you a clue. It's got palm trees. It looks very, very nice. I think it has a military base, if I'm not mistaken, as well. If anybody's getting warmer, so are they in this great U.S. jurisdiction of American Samoa. See, I did that. It's getting warmer, and the trees and the sun and the beach. That was all on the spot. And that's American Samoa.
I would love for them to create a condominium concept there. It would be really, really nice if they also allowed reciprocity so Florida lawyers could go practice there. Condo reserves. All right, so this is the old slide. I have not updated this to reflect the new law, but candidly, the new law, while it's in effect, is not in effect yet. And I'll briefly go into it. In a condominium, you need to be maintaining reserves for the roofs, the painting, the pavement, and any item that's going to cost more than $10,000 to replace when it reaches the end of its life. These things all historically need to be part of the reserves, but owners could vote to waive or partially fund them. Late breaking news as of this past summer or leading into the summer, Senate Bill 4D, you've probably heard about it if you've been in condo land for a few months, basically is creating categories of structural integrity reserve items, things that are going to become mandatory reserves unless the law changes by December 31st, 2024, which is when any budget adopted by your association after that date needs to include mandatory reserves for those items that constitute structural integrity reserves. It's not every reserve component, but it's most of them. And it's a lot of things that candidly none of us ever even thought of as reserve items, like the concrete structure of the building. That has historically not been part of reserves, but since Surfside people learned, wait a second, you don't want to be kicking the can down the road on your concrete restoration project financially, because you could end up in a pickle like tragically they did at Surfside. Not that it was the only cause necessarily. I'm not going to cast that judgment at all. That's for other people besides me, but everyone knows at this point that they had issues with the financial aspect of getting their restoration project off the ground. And have they had the money in reserves being gathered for a couple decades, which is what the new law is designed to basically do, then maybe they wouldn't have been kicking the can down the road quite as much, and maybe they could have avoided a catastrophe. Not here to Monday morning quarterback anybody. It's a tragedy all around, and then I'll leave it at that. To calculate reserves, there's two different methods to do it. There's straight line reserves and there's pooled reserves. Straight line is what you see on the screen. It's super simple. Let's say your roof costs $100,000 to replace. It's got a 25-year economic and useful life. You divide the 100,000 by 25 years, you should be gathering $4,000 per year. So at the end of 25 years, you have $100,000 sitting there ready to go. You can also adjust this for inflation a little bit. There you go. Take into account interest and inflation. It's almost like I knew what I was talking about. Continuing on with pooled reserves, though, this is a different one. And basically, it deals with a cash flow computation that more heavily weights the reserve expenditures that are expected to come up in the next several years, as opposed to 25, 30 years down the road or any more distant time horizon. And what it basically does by engaging in that type of calculation is it actually reduces the reserve contribution that is required on an annual basis, because it's de-weighting those things that are further down the road. It's kind of been a mechanism for a lot of boards historically to reduce your reserve contribution, even when you struggle to get the membership vote that's required to authorize the board to do that. The other thing it does, and this is the more common motivation for it, is it creates one big fund of reserves that can be used for any of the items that go into the reserves. Under straight line, where if you collected that $100,000 for the roof I was talking about, that $100,000 is only allowed to be used for the roof. Conversely, and so if you needed to do a paving project, you can't use the roof money for the paving project. But under the pooling method, it's one big fund, and you could use all of the money for a single item as long as it's part of the reserve contribution. So the pooling method gives you a lot more flexibility to spend the reserve money. All right, we covered this. Reserves can only be used for the intended purposes. Owners can vote to use reserves for other purposes. That goes to the idea of waiving or partially funding. You can also reallocate the money, but it takes a membership vote. HOA reserves, it's not mandatory by default. The developer can establish it as part of your practice. Some municipalities could even require it. If the first budget has it, that's historically been a reason to continue to do it. Also, if the membership votes for reserves, or if the declaration or governing documents mandate it, then it can also be a mandatory requirement to have reserves in an HOA. But again, it's less of a big deal in an HOA. The most important thing, if you have a clubhouse or significant amenities, that could be an important thing. The roadways can be an expensive item to deal with, but it's not like the condos where it's literally the roof over your head and the walls are the things that the association is responsible for. So having reserves so people don't, inherit a giant liability, having reserves in a condo is just way more important and way more heavily regulated. And by the way, if I didn't say it before, in the condos, because of the new bill, you're not going to be able, I did say it, just to emphasize it though, again, you're not going to be able to waive those structural items on a budget that's approved after December 31st, 2024. That law is also going to require you to do milestone inspections, which means that you have to go get an engineer or architect to inspect your building to make sure things are okay, so to speak. It's more involved than that. There's been a million webinars on it. I've done them. Castle's done them. And so you should watch them, but also be aware that that law is probably going to change a little bit is something else to note. So don't move too fast. Maybe it's your call, because a lot of the requirements in there may actually be modified before they truly come into effect. A side note here, investing reserves on the financial side, you're actually allowed to do it. It's something you should really think about carefully, because if you're investing reserves, like I said, most people don't want their condos taking on risk for them. And so if the market dips, you could have a real problem when you can't fund a big liability. So it's a choice, but you need to act prudently when you do it. If you don't, we covered this, you don't have to allow the owners to vote to waive or partially fund reserves. Good budget practice, always get bids, review your collections and your accounts receivable all the time. Make sure you're staying on top of the money coming in. Just because you assess doesn't mean you're going to have the cash. You need to actually stay on top of people and have a good collections protocol, hopefully, so that you always have the money coming through the door to fund your operations. At the end of the day, you're a not-for-profit corporation. Castle Property Management, a lot of people look to the management company to say, oh, well, the management company should pay for it. That's not how it works. The management company and all of the association's operations flow through the association. The association is funded by you, the owners. So you need to stay on top of your accounts receivable. Otherwise, you could have a budget shortfall where you're just not able to fund necessary operations. Collections. There's a new requirement in 2021. This is the process to go after the accounts receivable. You have to do a courtesy notice now. That's the first step to initiate your collection process. You are not allowed to charge attorney's fees for it. Management companies can charge a fee for it. So what I recommend to my clients is try to in-service your management team to have them be sending that initial letter, because they could charge a fee for it, even though by statute a lawyer cannot. After that initial letter is done properly, and you should confer with counsel and make sure you're doing it properly, then you can send what used to be considered the first letter. Now I just call it the collection letter, or the notice of intent to lien. And it says for a condo, you have 30 days to pay. And if you don't pay, then we get to put a lien on your property. And if you don't pay after we put a lien on your property, and that's a separate letter that goes with the lien, then after 45 days, we can foreclose on you and we take your property from you. If we ultimately don't get enough from the foreclosure sale to satisfy our judgment, then you have a deficiency judgment, which means you have a money judgment against the person. But honestly, especially in a condo HOA situation, if somebody's losing their home to a condo HOA judgment, which is tens of thousands as opposed to hundreds most of the time, then they probably don't have enough money to really be worth chasing after them individually. I've done it, but you have to be very selective when you pursue those matters, because at the end of the day, if somebody's willing to lose a $300,000 condo to a $20,000 judgment, there's usually a reason out there. There's probably a bank foreclosure, and they're probably, they've probably already turned their pockets inside out, so to speak. All of this could be appealed, but it is very rare in the collections context. Usually these things are pretty black and white. A couple different types of foreclosures, just to mention real quick. There's association foreclosures, there's mortgagee foreclosures, or like bank foreclosures. There's also other types like tax deed sales and foreclosures like that. There can be, construction lien foreclosures, but these are the two big ones. I mention it because when you're administering your collection process, you should always be mindful of the bank foreclosure or the mortgagee foreclosure, because you don't want to necessarily put the pedal to the metal on the association foreclosure and rack up big fees. If the bank is trailing right behind, you could get wiped out and wind up paying your attorney a bunch of money just for them to have gotten you a paper judgment that got you nothing at all. So you really want a good attorney that's able to see the whole field and not just be some sort of mill that's just pushing everything constantly and potentially wasting resources. All right, I think this is the last trivia question, and this is the one that I kind of forecast at the very beginning. This is a U.S. metro area statistic, so we're only national. What 3 counties have the largest percentage of their population served by homeowners and condos association nationally? Broward County, 32.5%. Palm Beach County, 29.8%. And does anybody have a guess for what the third one is going to be? Miami-Dade County, 27.6%. We are at the epicenter here of planned communities here in Southeast Florida. Average HOA fee, this is an old stat, I'm sure it's gone up as $310 per month. Estoppels. This is the line in the sand at a conveyance. Owners can submit requests for an estoppel. You charge a fee for it. It's indexed to inflation. It's been increasing lately in light of the inflation that's allowed these rates to increase. You can charge $250 for it, $100 if it's an expedited request, if it's a time-sensitive one, and if the account's delinquent, then you can charge another $150. So standard's $250. You can beef it up to $350 if it's expedited. You can even go to $500 if it's a delinquent account, and it could even be more than that because since this statute established these figures, it is something that has gone up due to inflation. If you'd like, there's a form for it. It's not just financial. It's also about open violations or special assessments or all sorts of other things. And there's requirements to return your response within a certain period of time. Otherwise, you can't charge for it. Getting close to the end now. The rentals I mentioned, you have an ability under the statute, and you can do this concurrent with your ordinary collections process. If an owner is delinquent to the association in an assessment, you can send what I call a rent demand letter to the tenant and to the owner saying, dear tenant, your landlord's a deadbeat. They're not paying the association. The owner owes us $7,000. We understand your rent is $1,800 a month. Pay us all of your rent until the account is brought current. And by the way, if your landlord tries to evict you for not paying rent, you get to go to court, show them this letter, and the judge is going to throw out the case because Florida law says that you are entitled to pay us instead, and it's a defense to their eviction action. Look at that. We got one more trivia. What country's laws were the basis for the first generation of U.S. condo law? Hungary is just, they just keep giving gifts. The 1924 Hungary Condominium Act is something that has been the model for our first generation of condo law. What's the last major country to adopt a condo concept? The Swedes. I don't know what the beef is the Swedes have with condos, but in 2009, apparently they got over it and we welcomed them to the party. So thank you, Swedes. We are grateful to have you here. I hear Castle will be opening up an office in Stockholm one day very, very soon. Jerry will be founding that office. How many condos are in Great Britain? None. They call them commonholds. The Brits have different names for everything. If there's British people on here, I mean it as a compliment. If there's nobody British on here, it's ridiculous. I don't know why they can't just use the same language as us. It's English after all. I don't think that really made any sense. All right. Continuing on, one property with 30 units in Wales, 12 properties with 97 units in England. All right. And now we're getting to the very end. Alternative dispute resolution. There's mediation and arbitration. It used to be mediation is for HOAs, arbitrations for condos. There was a recent legislative amendment that now allows for categories of disputes. It's a defined term that I'm going to get to on the next slide. Now can go to arbitration or mediation in the condo context. For HOAs, if you have an election dispute, you can go to arbitration. Otherwise, you're going to mediation. And here's the categories for the HOA pre-suit mediation process. It's a form that sets forth exactly what needs to go in the pre-suit mediation demand. Basically, you got to tell people that here's a list of 5 mediators. Mediate with me. If you don't mediate with me, I'm going to sue you. And if you don't mediate with me, by the way, and you win, even though it was my complaint, if you beat me, you can't recover attorney's fees if you didn't go through the pre-suit mediation process. Here's the definitions of what constitutes a dispute. I will not read it to you, but basically the things that are not arbitratable or mediatable in a condo, that's what you need to know. It's stuff that's about money. Or interpretation of statutes can sometimes be a thing. A breach of fiduciary duty claim is something that's not arbitratable. Title to a unit. These are the things that you're seeing in that right here, the types of disputes not arbitratable. That's what you want to be thinking about when you think about the things that should not be going to the ADR context, alternative dispute resolution, but instead go straight to court. There are requirements before you go through the arbitration process. It needs to be a dispute, an arbitratable claim. You need to be an owner of the association, and it cannot be a dispute between 2 owners. It's between an owner and an association. Instead of a complaint like you have in court, you have a petition. Instead of an answer, you have a response. You have motion practice. You have judgments. You have attorney's fees. They call the judgments typically a final order. More trivia. How many arbitration opinions were there from 2008 to 2015? 3,900. How many were appealed? 27. I bring that up because it's interesting to note that arbitration works. It was designed to be a cheaper way to get quick solutions that cut down on the attorney's fees, and it works. 3,900 cases, only 27 were appealed to the court system through the process called a trial de novo. It's not technically an appeal. It's a trial anew, but it's resolved so many disputes. And then this is the very last thing for the HOAs out there. Not going to go into a crazy, but if you are anywhere near 30 years into the life of your HOA, check the recording date of your declaration as originally recorded. You need to be mindful of the Marketable Record Title Act. And this is a critical item. If you screw this one up, it will be catastrophic potentially to your community. What happens is after 30 years due to this statute, the Marketable Record Title Act, your governing documents can expire. And which means all the things that protect your common scheme and your governance could go away and require a membership vote to reactivate, which means someone could be building a 20-foot wall without architectural approval, which means they could be building, monstrosities that you'd never allow. It could mean that you're doing all sorts of things that are just wrong. You could lose your power to assess people for a period of time. Really tough. Try to get a membership vote done without any financial resources. Challenging stuff. But if you do it before the 30 years, you can do it upon a mere board vote. But you need to stay on top of this. If you're anywhere near 30 years and you're an HOA, that almost never applies to a condo. But if you're an HOA, you need to be mindful of this deadline. And with that, I did go a little bit over, but it was only because Jerry made too many good jokes. It's 2:06 p.m. I thank you so much for being here. I'm going to jump off the screen share if it's okay, Lindsay. Can I give up this graphic?
Well, yeah, sure. Before we go, if anybody has any questions in particular, please email info@castlegroup.com. I'll be sure to answer. And if anything is directed at Michael, I will share his information as well. Just so you know, your certifications will come directly to your email. We will use the email you registered with. So if there's any difference in that, please email info@castlegroup.com or my email, which is lreyes, my name up here, lreyes@castlegroup.com, and I can address it directly. Is that okay, Michael?
Of course.
Okay.
And if anybody wants to reach out to me as well, feel free, but Lindsay's got my information. You can find me on the website. My email address, if somebody wanted to write it down, is mkassower@fwblaw.net. And other than that, I just want to say before we go and look at people again through the camera, I want to say honestly, Jerry and Lindsay, thank you both so much for letting me be part of this today. I actually like what I do, so I joke around a lot, but I appreciate the opportunity to be part of this today and join the Castle team and look forward to working with you all more. And to all the board members out there, congratulations if you were just elected, or my condolences, depending on how you want to look at it. You're doing a good thing. It's yeoman's work. You're going to get criticized probably, but it's really nice. And I congratulate you on doing a nice thing for your community. And thank you again to everybody for being here and for the opportunity.
Yeah, great job, Mike. Your passion is infectious. Obviously, you love what you do. It's clear in your presentation. That was very informative and fun. So again, everyone, thank you very much for joining us, and keep an eye on your emails. We'll have new webinars coming soon, especially after the new year. But always happy to help, and reach out if you need anything.
Yeah, and this is going to be posted on our website, just so you know. If you want to refresh, it will be posted to www.castlegroup.com/webinars, or you can just go to the website and click the webinars tab. It will be posted there. So if you want to review or go over anything, it will be there as well. Thank you all. Have a wonderful afternoon.
Thank you so much. Take care.
Thank you, Michael. Bye.
Thank you.